Thanks, Louise. Ladies and gentlemen, you will have noted that the particular topic of this session is judicial method. And those two particular words, would remind many of the lawyers among you of Sir Owen Dixon's famous paper, delivered in 1955 and entitled Concerning Judicial Method. In that paper, many of you will recall, Sir Owen criticised what he saw as a recent development, namely deliberate innovation by judges bent on changing acknowledged legal doctrine. The chief objection which Sir Owen had to this phenomenon was that he said that by such innovation, the judge wrests the law to his authority. Sir Owen concluded that particular address by referring to such innovation as, and I quote, the abrupt change of conceptions according to personal standards or theories of justice and convenience which the judge sets up. And he finished by saying that if this were to continue, and again I quote, the better judges would be set adrift with neither moorings nor chart. Now today we would call the phenomenon of which Sir Owen spoke judicial activism. Unfortunately, it's become far more prevalent today than it was when Sir Owen spoke years ago in 1955. Indeed, today we have at least two new forms of judicial activism in addition to the judicial innovation of which Sir Owen spoke. The first of these is what I would call a much greater willingness on the parts of the courts to extend judicial review of executive action into the political arena, that the political arena being an area previously regarded as largely unreviewable. The other more recent form of judicial activism I want to suggest is the deliberate expansion by judges of their role into areas traditionally regarded as a matter for Parliament. So it's these two things, expansion into the role of the executive and also expansion into the role of the Parliament. In that way, the courts have reduced the role of both Parliament and the executive and also increased their own influence. So there, I suggest, the two more recent forms of judicial activism. And today, I want to talk about all three of these forms of judicial activism. And in doing that, I'd like to focus on a recent case, which I want to suggest is a particularly egregious example of all of these three forms of activism. Now, the case, as you'll have seen from the title of my paper, is a decision of the UK Supreme Court in 2019, which I've called the Prorogation Case, or to give it its more formal title, it's the Crown Miller and Prime Minister, which is reported in the appeal cases for 2020. Now, I've only got half an hour at my disposal, and in that time I'd like to concentrate on five things. First of all, I want to say something about prorogation. Second of all, I want to give a little bit of background to the case to put it in context. Thirdly, and this is probably the most important section, I want to look at the reasoning of the UK Supreme Court in that prorogation case. Fourthly, I want to look at some problems with the Supreme Court's reasoning, and finally, I want to draw together some conclusions. Now, starting off firstly with the notion of prorogation. Prorogation, as most of you will know, put very simply, is the termination of a session of Parliament. Now, in the UK, a session of Parliament begins, and many of you will have seen this on the television, with a ceremony in the House of Lords, where the Queen opens the Parliament in the presence of MPs, their various speeches and other formalities, and all of that is recorded in Hansard. So that's the opening of Parliament, or the beginning of the session. Similarly, there's a a session of Parliament ends with a very similar ceremony in the House of Lords, which we call, and we call that ceremony the Prorogation of Parliament. Now, the prorogation ceremony is also attended by the MPs, and again, there are various speeches and formalities, again, all recorded in Hansard. And if you want to get a sense of the pomp involved, if any of you subscribe to the London Times, a couple of days ago there were some photographs of the prorogation ceremony which occurred this week. Now, this prorogation ceremony, as opposed to the opening of Parliament, which I think is always attended by the Queen, the prorogation ceremony can occur in either of two ways. The first is that the prorogation can be effected by the Queen in person, which involves the Queen attending the Parliament, attending on the floor of the parliamentary chamber of the House of Lords, and proroguing the Parliament there in person. Now, alternatively, the Queen can, by an order in council, authorise members of the House, who they call commissioners, to attend the House of Lords and prorogue Parliament on her behalf. Now, the latter is the more usual practice, and that's what happened back in 2019 before this case, which I've called the Prorogation Case. Now, the power to prorogue is one of the Queen's prerogative powers, and again, most of you will know that by convention it is generally exercised by her on the advice of the Prime Minister. Now, prorogation has quite a few consequences. The most obvious one, and probably the most significant of these, is that Parliament does not sit during the period after the session has ended until the new session of Parliament commences. So that means, for example, that, and very obviously, no legislation can be passed during that period, and it also means that ministers, the Prime Minister and other ministers, can't be asked questions on the floor of Parliament, and in short, there is no parliamentary business that takes place. Now, like most things in the world of politics, a Prime Minister may advise a prorogation in order to obtain a political advantage. It's not the usual case, but there are examples in the books, historical examples, where it's been said that and it's happened in this country as well, where the Premier or Prime Minister has taken advantage of this procedure to try and get some advantage over his opponents. Now, there are many examples that could be cited of that over the years in both the UK and for that matter here as well. Perhaps the most notorious example happened in Canada in 2008. And what happened there was that the Prime Minister, Stephen Harper, sought and obtained a prorogation of the Canadian Parliament, and he obtained a prorogation for some months, not a period of just a few days. And the reason he did it, or so it was said, was in order to avoid losing a vote of no confidence on the floor of the Parliament. So if you imagine today, if here in Australia, you might get a similar situation arise if there was a minority government and the crossbenchers shifted their allegiance. You can see why a Prime Minister may want to prorogue the Parliament for even a couple of months in order to try and get the crossbenchers back into the fold. That's the sort of situation I'm talking about. Now, the power can be used for such political advantage, even blatant political advantage, obviously raises the question as to whether there are any restraints or constraints on the use of this particular power. Now, constitutional lawyers who've looked at this question have traditionally pointed to three things in that regard. The first is obvious, namely public opinion, and by that I mean that if a particular prorogation is thought to be contrary to constitutional conventions or otherwise inappropriate, then it may cause damage to the government's popularity and therefore to its electoral prospects. So that's one constraint. A second is that, and it's obvious if you think about it, is that the Parliament can legislate to stop a prorogation. They can do that in two main ways. There are others, but the first is if the Prime Minister has foreshadowed a prorogation, but the prorogation has not yet occurred, then it's open to Parliament, if the members want, a majority wants, to prohibit that intended prorogation by legislation. So they can simply pass legislation and say the Parliament will not be prorogued, say, in the next 2 months. The other situation I want to mention is if the prorogation ceremony, which I just described, has already occurred, but the session has not yet concluded, then the Parliament may, in effect, quash the prorogation by legislation, provided, as I say, that the Parliament is still in session. So that's slightly different. It's where the ceremony has occurred, but the prorogation won't take effect for a few days. In that situation, the Parliament can sit, they can pass legislation, and they can, in effect, quash it. Now, the third restraint is something familiar to most Australians of a certain age, and it's this, that if the prorogation advised by the Prime Minister is contrary to constitutional conventions or constitutional principles, then the Queen, almost all constitutional lawyers agree, has a personal prerogative, or, you guessed it, a reserve power to refuse to follow the Prime Minister's advice. In other words, she can exercise a reserve power to refuse the Prime Minister's request for a prorogation. So they're historically, in the minds of most constitutional lawyers, the three main constraints on prorogation. It's important, though, that I note at this point that at least in the UK, or for that matter, Australia, New Zealand and Canada, there isn't, at least to my knowledge, any example of a court intervening in relation to a prorogation, that is a court engaging in what we lawyers call judicial review to determine whether the prorogation is invalid. That is, there was no example of that phenomenon, at least before this case which we're about to discuss. Now, can I say next, I said I'd give you some background on this particular case, and you'll all remember that in late 2019, the UK was in the midst of negotiations leading up to what was generally called Brexit, that is the exit of the UK from the European Union. And a date, you may recall, of 31 October of that year had been set as the date for the UK to leave the EU. And the principal outstanding issue was whether the Brexit would be what the newspapers were calling a no-deal Brexit, or whether the Brexit would be the subject of a detailed agreement. Now, what happened was that at some time, probably in August 2019, the Prime Minister Johnson advised the Queen to prorogue the Parliament, and he advised her to do so for about 5 weeks, which is a bit longer than normal, from mid-September to mid-October 2019. What then happened is that the Queen decided that Parliament should be prorogued for that period, and on the 28th of August she executed an order in council. Remember, I talked about this alternative form of prorogation, And by that order in council, she gave her authorisation for commissioners to attend the House of Lords on her behalf, to prorogue the Parliament from about 12 September to 14 October, and they also were authorised to assent to any bills of the Parliament which were awaiting assent. Now, the effect of that prorogation, if you reflect on the chronology, is that there would be about 17 days between the reopening of Parliament on the 14th of October and the exit day on 31 October. And I suppose lying at the base of all of this is a concern on the part of some that wasn't enough time for the Parliament to do its job, to perform its role before the exit day on 31 October. Now, on the 9th of September, and the dates are important for reasons I'll come back to, on the 9th of September, the commissioners, who, as I say, were all members of the House of Lords, they attended the House of Lords in formal regalia, tricorn and bicorn hats and robes and what have you. A very lavish ceremony which comprised speeches and other formalities. They prorogued the Parliament, as I said, from the 12th of September to the 14th of October. Now, it's important to note that this prorogation ceremony, which occurred on the 9th of September, had the effect of leaving 3 days between that ceremony and the end of the parliamentary session. Now, that's going to be important for a point that I'm going to make later on. In other words, the prorogation ceremony occurs on the 9th of September, 3 days before the prorogation actually takes effect. Now, as I've said, this ceremony was attended by MPs from both houses. It took place in accordance with standing orders of the House, and Her Majesty's assent was given by the commissioners to some legislation. And this whole thing was then recorded in the minutes of proceedings. You'll notice that's what it's called, the minutes of proceedings of both houses of the Parliament. Now, what then happened, and this is where the lawyers come in, is that 2 legal challenges were brought in the courts to the prorogation. One of these was instituted in London by a Ms. Gina Miller, and the other challenge was brought in Scotland. To simplify things, I'm just going to focus on Ms. Miller's case. Now, Ms. Miller said that this prorogation was invalid basically for 2 reasons. She first of all asserted that the prorogation was invalid because it was contrary to the constitutional principles, she asserted, of the UK. The other thing she said, or other argument, was that the Prime Minister's advice to prorogue, she alleged, was given for an improper purpose. And that improper purpose was to stymie parliamentary scrutiny of the Brexit negotiations then occurring, and also to prevent Parliament from legislating in the period before the Brexit negotiations were completed. So you see her argument. Her case was first heard in a lower court, the Divisional Court, and they rejected her arguments, and they held in short that the decision to prorogue was not reviewable in the courts, and they said the reason for that was that it was a political matter and it wasn't governed by legal standards. Now, that was, if I may respectfully say so, a result which was not surprising to most constitutional lawyers. Now, she then appealed to the UK Supreme Court. The court allowed her appeal and accepted one of her arguments. They didn't deal with the other. They accepted her argument that the prorogation was contrary to constitutional principles. The court also looked at another issue, namely whether the prorogation was a proceeding in Parliament within Article 9 of the Bill of Rights. Article 9, you'll recall, basically says that the courts can't review anything which amounts to a, quote, proceeding in Parliament. And so her Article 9 argument meant that, I withdraw that, the effect of Article 9 then was, as I said, that it was a matter for the courts, not for Parliament. Now, consequently, the court held that the prorogation was invalid. They rejected the Article 9 argument and they held that the prorogation offended the constitutional principles which we're about to discuss. Now, dealing first, there's two parts of the court's reasoning. The first is on the constitutional principles, and there's really four main aspects of this. I'm sorry this is so technical, but it needs to be in order to digest it and to show what's wrong with the reasoning. The first point was that they said that there was a common law principle, common law constitutional principle called the principle of parliamentary sovereignty. And under that principle, statutes enacted by the UK Parliament are the supreme form of law. So that's the first proposition. The second is the court held that there was a second common law constitutional principle which they describe as the principle of parliamentary accountability. And under that principle, as most of you would know, ministers are accountable to Parliament, for example, by answering questions in Parliament and appearing before parliamentary committees. Now, the third point in their reasoning, and this is the critical bit, is the court held that in order to avoid any conflict between those first two principles, that is parliamentary sovereignty and parliamentary accountability, to avoid any conflict between those two principles and a prorogation, the power to prorogue was subject to what they described as a legal limit. A legal limit. This was said to be supported by a number of cases, and this is the only bit I'm going to read out. This is how they described this particular limit. They said that for the purposes of the present case, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In such a situation, they said, the court will intervene if the effect is sufficiently serious to justify such an exceptional course. So that's the legal principle on which most of their reasoning hangs. The gist of it is that if the courts think that the prorogation is, and this is probably the most important word, an unreasonable fetter on Parliament doing its job, then they will hold that the decision to prorogue is invalid. Now, you'll have noted that word unreasonable. There isn't, in the minds of many commentators, much difference between a court saying that someone else's decision is unreasonable on the one hand and saying that they simply don't agree with it on the other. Now, the fourth and final bit is that the court applied that principle to the particular circumstances, which I'm not going to discuss, and they said the decision to prorogue was invalid because it frustrated and prevented Parliament from carrying out its constitutional functions at this particularly important time, and they said there was no reasonable, that word again, no reasonable justification proffered for the prorogation. So that's the first bit of their reasoning on constitutional principles. On Article 9, that is whether or not this prorogation in the Parliament amounted to a proceeding in Parliament, one might have thought, even from what I've said so far, that the speeches and formalities in the House of Lords were fairly obviously a proceeding in Parliament. And as I said before, if they're a proceeding in Parliament under Article 9, then that means, in effect, the courts don't have jurisdiction, and it's a matter for the Parliament, not before the courts. Now, why do I say it was fairly obvious that this was a parliamentary proceedings? I'll just run through a few points quickly. It was a ceremony conducted on the floor of the House of Lords, attended by MPs from both houses, attended by various parliamentary office bearers. There were speeches and other formalities. Assent was given on behalf of the Queen in Parliament, as they call her, to some legislation, and assent being a clear legislative and parliamentary act, which the courts have previously treated as unreviewable. Next, the commissioners were all members of the House of Lords, and they were again representing the Queen in her role as the Queen in Parliament. Everything that happened is recorded in Hansard. The prorogation is recorded in the minutes of proceedings of both houses, and this all happens in accordance with the standing orders, which are the rules, as you all know, about parliamentary procedure. The question being whether this was parliamentary proceedings. Now, the Supreme Court, and this is the last bit of the reasoning, held that the prorogation ceremony, they said, and I find this a very curious wording, they said the ceremony, quote, cannot sensibly be described as a proceeding in Parliament. Cannot sensibly be described. Now, one would expect, if they're going to, in effect, criticise the argument put on behalf of the Prime Minister about Article 9, that they'd have some pretty strong reasons for holding that this was not a proceeding in Parliament. Now, as far as I can make out, there are really only two things that they say in this regard. The first is that they say that it did not fall within the core or essential business of Parliament because it did not constitute a decision of either House and was not a matter on which MPs could speak or vote. Secondly, they said that the prorogation, and I find this very odd, the prorogation was something which was imposed upon the Parliament from outside the Parliament. So that's their reasoning, and they don't really elaborate on that at all. I said to you the fourth thing that I wanted to look at was to look at what I consider to be some problems with this reasoning, and I'm sorry this is so technical, but this is the bit where we look at the difficulties in the way they've put this analysis together. Can I deal, since we've just dealt with it, first of all with whether this is a proceeding in Parliament? Now, I think there are a number of problems with what they've said. The first is that you'll remember when I rattled off a whole lot of factors pointing towards this being a proceeding in Parliament, recorded in Hansard, the minutes of proceedings, etc., all that sort of thing. Well, the first problem is they don't mention, do not even discuss any of that at all. So this is, I want to suggest later on, an example of the court just trying to draft this judgment or fit it to reach a particular result. They simply do not mention all of the arguments which would favour a finding that it is a proceeding in Parliament. The second problem I want to suggest with the way they analyse it, you remember that I emphasised this idea about the core or essential part of parliamentary business. The second problem is that I'd suggest it's a non sequitur to determine, as the court did, whether something lies within a particular concept. Here the concept is the concept of a proceeding in Parliament. Whether something lies within a particular concept by focusing on whether it lies at the core of that concept. That, I suggest, is obvious, and it's obvious because any concept will include matters not only lying at its core, but also matters that come within its periphery. So if you say, well, that's the concept there, here's the core, what we're talking about doesn't come within the core, well, that doesn't determine the question. The issue is, does it come with this area here, whether the core or whether the periphery? Now, the third problem I want to suggest is the statement, and they don't really elaborate on this, that the prorogation is imposed on the Parliament from outside. And as I say, there just isn't anything that they say clearly about this. If the court's talking about the Queen, I'd suggest that it's just nonsense, because the, quote, Queen in Parliament, unquote, is part of the Parliament, because the Queen is part of the legislature of the United Kingdom. So it can't mean the Queen. If the court is talking about and referring implicitly to the advice given by the Prime Minister to the Queen, then I'd suggest that's also highly problematical, because if, as almost all constitutional lawyers accept, the power to prorogue is a personal prerogative, that is reserved power of the Queen, then the decision to prorogue is, in the end, a matter for her, not for the Prime Minister. Now, extraordinary as it may seem, the court adverted to this critical question of whether this was the Queen's personal prerogative, but ultimately said, this is at paragraph 30, that they were expressing no view on the matter. So I suggest their reasoning is highly problematical, to the point, I think, of being bewildering. So that's Article 9, and the last bit of this analysis is to focus on the constitutional principle that they articulated. The first problem with it, and you'll be pleased to know I'm coming to the end of all this, the first problem is that I'd suggest it's a very clear example of what Sir Owen Dixon called judicial innovation, or what I would call, using the vernacular, just making it all up. And now, I say that for a number of reasons. One is that this key principle, that's the bit that I read out carefully to you, they say that the court says that that principle is supported by the case law. But if one has a look at it, the case law that they refer to, it doesn't provide even the slightest support for this proposition. The cases for the lawyers among you are cases simply about statutory interpretation, and they are so wide of the mark that there isn't even any point in cutting them up and trying to refute the analysis based on those cases. Next, there's no case cited by the court that this, remember they talked about this notion of parliamentary sovereignty, and they said it gives rise to this other constitutional principle. They don't cite any case which suggests that parliamentary sovereignty, as it were, gives birth to other constitutional principles. Next, they don't cite any case which suggests that this other notion of parliamentary accountability gives birth to other constitutional principles. Nor does the court refer to the writings of any scholar, or indeed anybody who provides or who has suggested the existence of anything like this key principle they refer to. Next, to suggest, as they do, that all they were doing here is determining the extent of this particular prerogative is, in the words of one famous constitutional scholar, utterly disingenuous. And I say that because to articulate a test of 8 lines, which is then used to determine the validity of an exercise of a power, is, I would suggest, on no view, an attempt to define that particular power. And the test finally focuses on this notion of reasonableness, but I'd also suggest that if you're talking about the reasonableness of a decision to prorogue, that can only be determined by reference to constitutional conventions. Otherwise, how do you determine whether it's reasonable or unreasonable? The problem with that is that if constitutional conventions are relevant, then the courts can't look at the issue. And the reason they can't look at the issue is that all of the cases in this area say that compliance with such constitutional conventions is not a matter which the courts can review. You guessed it, because it is a political matter, not a matter of law. Finally, and I've already remarked on this, this test of reasonableness amounts, I would suggest, to a fairly unsubtle device to enable unelected judges simply to substitute their own views on matters which are not legal but rather political. What's, and I'll finish in the next minute, what's perhaps even more disturbing about this judgment is the way that the court introduces this key principle that they formulate, is that they introduce it in a way that implies that there are going to be further examples of this principle which will be enunciated in future cases. So we're apparently to, as they say, watch this space for further novel developments by the court in this area of the constitutional law of the UK. To be blunt, the court has, in my view, simply invented this key principle. They have, as I said a moment ago, in my view, simply decided that they are going to invalidate this prorogation, and they have fitted up all of this judgment in order to achieve that result, either, as I've said, by bending principles or simply by inventing them. They've also, so that's the first species of activism which Sir Owen Dixon talked about. They've also invaded the political arena and engaged in this second species of activism I referred to at the beginning by extending judicial review of the executive deep into the political arena, which, as I said at the beginning, is an area largely unreviewable, or held to be largely unreviewable because there are no legal standards. Finally, this is, although they keep referring to this notion of parliamentary sovereignty as a key concept, the difficulty is that their reasoning, in my view, flies wholly in the face of that principle for at least two reasons. The first is, and you'll remember our discussion earlier about this, is that the Parliament could, by legislation, have prevented or quashed this prorogation in the period between, remember the dates, between 9 September, which was the date of the ceremony, and 12 September, when the session ended. So the effect of that is that the Parliament must be taken to have decided not to quash the prorogation by legislation, or putting it another way, the Parliament must have decided, or the members of Parliament, that Parliament could perform its constitutional functions without reversing the prorogation. So what the Supreme Court has done is that they've chosen to invalidate the prorogation when, in effect, Parliament had chosen not to, which directly contradicts this notion of parliamentary sovereignty, which the court claims to be championing in the judgment. The second thing is that reason that it flies in the face of parliamentary sovereignty is, as we've already noted, that this was, at least in my view, clearly a proceeding in Parliament, and therefore, under Article 9 of the Bill of Rights, the validity of the prorogation was a matter for Parliament, not a matter for the courts. So again, they've invaded parliamentary sovereignty in that respect. Ladies and gentlemen, can I conclude my discussion with a couple of observations? The first is that this case is, in my view, a very striking but also a very worrying example of judicial activism. It involves quite deliberate judicial innovation of the most extreme kind. It constitutes a very substantial inroad into parliamentary sovereignty, despite the fact that the court claims to be championing that very sovereignty. And it's a grave intrusion, I want to suggest, of judicial review of the executive into the political arena, an area previously regarded as largely unreviewable. My second concluding comment is this, that I think that future cases in the UK Supreme Court in this area could go either of two ways. The first is that the court may react to the criticism of this decision and you may assume there's been plenty of it, by adopting a more conservative approach in this area. However, I think, unfortunately, that it's more likely that this particular case is a harbinger of further expansion by the British judiciary in this area. It's reasonably clear, in my view, that the UK Supreme Court has in effect embarked on a course of inventing a swathe of new constitutional principles designed to increase the power of the courts and diminish the powers of Parliament and the executive. I conclude then by congratulating the Society on the strong stand which it has taken against judicial activism since its inception, and I'm very grateful to the Society for enabling me to make a very small contribution to the debate on that topic.